starting your day, or maybe not starting your day. Having this as your second act here at AEI, we really appreciate you being here. I am so excited for this discussion. We did a prep call a week ago, and I've just thought about it ever since then. One of the things that Viet Din said is this is really a metaphysical, situation. We need to think about all the zeros and ones, as I think. And I realize this is a bit of a generational thing, but I think about that when I'm in my car and I'm listening to the radio. And I never question it. The radio's always been there, but I think about Wi-Fi, and it still to this day fascinates me. I realize that there's a whole generation of people who take it for granted, like I do the radio. And I have to thank. We have one of our AEI colleagues is one of the co-founders or the people that help put the Wi-Fi together, and I can't ask him enough questions. He gets a little tired of me. So we are going to have a fantastic discussion. Viet Din's going to open for us. He is the founding partner of Bancroft PLC, and he is also a counselor to Microsoft, so we're all clear on that as part of the Mercury Group. I love this line. He advises individuals and organizations through high-stakes conflicts, existential risk, and national security issues. I feel like if I'm having an angst moment and I'm in my car, I might call him, like, I don't know, the bridge, are we sure? He's also a lecturing professor at Georgetown University, and he served as the U.S. Attorney General during a really key part of the initial part of this discussion, which is right after 9/11, which was, I hadn't thought about that when we were having the prep call on this, how important that moment in time was, and trying to guesstimate where a lot of this was going. And we're seeing this now in 2015. A lot of challenges. The Microsoft Ireland case is one, and I actually have a copy of the amicus brief, which Laura has given to me. So if anybody wants to know exactly where you need to go, she's really outlined a fantastic discussion here. So we're going to have a great dialogue. Viet, I'm going to open it for you, and then we will go to a panel discussion at 10.
Thank you very much. My name is Shane Choos. Thank you very much, Shane, and thank you very much for that introduction. AEI member inventing Wi-Fi. I did not know that Al Gore was
Co-founder,
here.
right? Yeah.
I did not know that Al Gore joined AEI. And it's also very, very appropriate for us to talk about the beginnings of technology because the history of lawful intercepts is a series of conversations between the judiciary and Congress. And I think now is a particularly appropriate time for us to have this conversation because it is now prime time for Congress to get back into the conversation and to act on this particular matter that is the Electronic Communications Privacy Act, ECPA reform. Why is that? Let me take a step back. You'll recall traditionally the Fourth Amendment protects person, places, or things, the traditional trespass theory of the Fourth Amendment. In 1967, of course, in Cass v. Maryland, the Supreme Court changed that landscape by holding that the Fourth Amendment actually also protects reasonable expectations of privacy. In that case, a FBI surveillance of an outside of phone booth, when closed, the Supreme Court held that evinces a reasonable expectation of privacy, even though the phone booth was public and in the public space. So that transformed the traditional trespass theory into the modern-day reasonable expectation of privacy theory of the Fourth Amendment. In response, the very next year, Congress passed Title III of the Omnibus Crime Act of 1968, what we all know as T3, which is the wiretap statute. And so where the court speaks and innovates the theory of privacy protection, Congress responds by giving a more detailed framework with which law enforcement, as well as civil libertarians, as well as individuals, can order their lives so that we have the system of order liberty that we all enjoy in this country. Fast forward, 1979, Smith v. Maryland, where the court faced the question of a pen register, which is the device that captures all outgoing calls on a particular telephone. The court held that it was not a search or seizure because it only captures information that the person was emitting to the telephone company in order to effectuate the connection. And that is given to a third party. There should not be a reasonable expectation of privacy on information that you voluntarily give to a third party, in this case, the phone company. reasonable enough, the reasoning, Congress responded by enacting the Electronic Communications Privacy Act, part of which was the pen register statute, which puts some roadblocks, minimal but significant enough roadblocks requiring court approval for a pen register, the device to be put on a telephone. Part of that ECPA of 1986 is the Stored Communications Act, which brings us to the modern day, as it existed then, with electronic communications. Stored communications is nothing more than a fancy word for emails, whereby we give to a third-party provider in order to store. Now, if you think about the theory of the Fourth Amendment then existing, we're giving information to a third party to store. One can analogize that fairly easily to the digits that one gives to the phone company in order to effectuate a phone conversation, right? Because it is information that we're giving to a third party. But it's a little bit different because we're giving it to them not just simply to transmit a message, but also it embodies the message itself. And so that's why the Stored Communications Act puts a much higher standard for lawful access, law enforcement access to the contents of those stored communications. But again, the prevailing theory was that this is noblesse oblige by the government because the Fourth Amendment does not protect this. So the Stored Communication Act was extra protective of Fourth Amendment and privacy interests, and what it required a court order upon showing probable cause before a law enforcement agency can access the contents of a stored communication, an email. But now, when you think about it, because a stored communication, an email, is simply something we give ones and zeros to a third party to store for us, that permission to store at some point expires. And Congress says 180-day is pretty much the extent of which we'll protect that. After 180 days, your email is deemed to be abandoned, and therefore you can get it at a much lower standard than that which protects the emails that are fresh in 180 days. Right? May have been logical at the time because that's the framework that Congress is thinking of. We're protecting content that otherwise is not protected by the Fourth Amendment, and we'll give that protection 180 days. If you don't take other steps in order to preserve it, then we'll think of it as abandoned. Completely antithetical to how we see emails today. Right? I don't know about you, but I don't have a file cabinet. My file cabinet is my inbox. The ones that are older than 180 days are my crown treasures. Right? The pictures that are there for 3 years ago, that's where I store them. And I go in my search box in order to find those pictures. Right? The ones that are within 180 days, obviously I care about their content, but they're not as important to me in terms of what I treasure as 180 days. But in any event, that line just doesn't make any sense in terms of my privacy interest and my expectation that all my emails are private. Right? So at the very least, now is a time for Congress to look at the lines that were drawn at one time that may or may not have been logical, but certainly is no longer logical here in this day, in this age, where there is significant the privacy interest that is widely accepted. And indeed, the Sixth Circuit has held that notwithstanding what ECPA did, notwithstanding what the law was in 1986, the Fourth Amendment now protects the contents of emails just as it protects other the papers and effects. So the contents of email, at least within the Sixth Circuit, is held to be subject to full Fourth Amendment protection. And all of law, I have not heard any law enforcement agency that does not respect that ruling from the Sixth Circuit, and indeed all the service providers I've talked to respect that as the law of the land. And so there's a wide consensus that there is Fourth Amendment protection on the contents of the email. Fast forward to the period that Shane was talking about when I had the privilege of being in office, which was 2001, right after 9/11. And Congress, again, given the charge by the President and the people to update the law to the technology. We looked at this, and we looked at the situation whereby the laws, the governing Title III was created when there were rotary phones, and the laws with respect to ECPA was enacted in 1986, And then 2001, when much of that communication was electronic, we sought to try to update the laws to the technology. So for example, Congress took a look at the pen register statute and said, interestingly, some courts in the country have not allowed the use of pen register statute to find the routing information of emails because it was literally phrased as pen register and trap and trace device. And so what the USA Patriot Act did was translate that to the digital world, allow for the pen register statute to get non-content-based information, the routing and the addressing information of an email, just as the digits were given to the phone company. That can be obtained by a court order, but subject to a very low standard of proof. Right? So that's a typical updating of the law to the technology, at the same time not touching the content protections or lack thereof with respect to that applies to the subject line and the body of an email, the core content protections. At the same time, Congress took a look at the Stored Communications Act and said, we have faced a significant problem in law enforcement whereby electronic communications, by their nature, move across district very, very quickly at the speed of light. And so, in the old days, when we went to each district in order to do an investigation, that may have been efficient. But now that emails are located at both ends of the communication, and those ends are national, we want to be able to get a general multi-district nationwide warrant for stored communications for emails. And so Congress eliminated the district-by-district application of these warrants so that all 93 districts are now one nation in order to get a nationwide warrant to access emails because the communication is increasingly national. Both of those changes becomes important because we left one thing unaddressed because Congress did not envision or presage the advent of technology where it is today, which is totally global cloud computing, whereby sort of like instead of the normal scale-up architecture of building a supercomputer, the old Cray supercomputer or the old mainframes, in order to increase storage and processing speed, the technology in the last 5 years has been to scale out, which is to link up a lot of small computers with small processors, and thereby creating a massive supercomputer that is located all over the world that we metaphorically, but not really, call the cloud, because that cloud exists in little servers everywhere around the world, in data centers around the world. Right? That advent of technology, Congress did not envisage and therefore did not address in the USA Patriot Act reforms to ECPA. And that gives rise really to the case that we're here to discuss, which is I must admit, I marvel, I almost weep at the ingenuity of the law enforcement the personnel. I love it. Being from law enforcement itself, I admire the ingenuity. For example, GPS devices, a case before the Supreme Court 3 years ago in United States v. Jones, right? GPS devices, if you recall, the third-party doctrine is all in public. You're putting onto a car bumper. It's completely subject to the third-party doctrine under Smith v. Maryland. No protection under the Fourth Amendment, or no warrant requirement under the Fourth Amendment. The D.C. police in a drug investigation says it takes so much time and effort and money to follow somebody 24 hours a day for 30 days. Why don't we just stick a GPS device on the bumper? And then we can figure out where he goes every single day for 24 hours a day for 30 days, and we'll find the stash house, right? If any of you watch The Wire, you all know how important it is to find the stash house, right? Because you never want to take down a single drug dealer. You want to take out the stash house, the main stash. And so they found the main stash, and they busted them for conspiracy. The Supreme Court held unanimously, in 3 separate opinions, that even though the public nature of the bumper means that normally there would not be the full protection, Fourth Amendment protection. You require a warrant in order to do pervasive 24 hours a day, 30 days a week surveillance using a publicly available device. Why? Because there's something much more fundamental about the ability of the police to collect massive amounts of data and process it through the analytics that is different from a single snapshot at any given moment. Right? So the advent of increased computing power, the advent of increased storage power gives rise to both innovative law enforcement techniques, but also a legal response by the court and I would submit by the legislature at this time. The case at hand involves the same kind of innovative, creative techniques. Normally, the world is divided into territories, right? We had 93 judicial districts before. Congress eliminated that, but reaffirmed by that action, by negative implication, that the world is still limited by the territory that we control, which is the territory of the United States, plus some 2 miles off the beach in our territorial waters. That's our territory. Correspondingly, our territorial reach does not reach into somebody else's territory. It's very clean, very simple. We have absolute domain over our territory. Others have absolute domain over their territory. The only possible exception is that I, as a U.S. national, is subject to U.S. law wherever I go, and so the United States can act upon me even if I am in Ireland, right? But therein lies the innovation. I mentioned Ireland is because Microsoft has servers, as do most of service providers in Ireland, in order to service their European customers, because the lag time in accessing that data is much less if you don't have to go underneath the Atlantic Ocean in order to access that data. But because Microsoft is located here in the United States, they have an access point here in the United States at corporate headquarters, because they would like to be able to access that data. If the customer moves to the United States, they want to locate that back to the United States, or they can access the information in order to do maintenance and other network infrastructure activities. The innovation comes, the DOJ, through the Southern District of New York, issues a subpoena to Microsoft, say, hey, I know that your data is in Ireland, and I can go to Irish authorities in order to get that information. That is a viable but very cumbersome, understandably, process, because I have to go through a sovereign to sovereign process in order to get the Irish to act on my behalf in order to assist me in my law enforcement. It's much easier for me to go to Microsoft and issue a warrant to Microsoft to use that access point in order to get access to data in Ireland. And this is where I refer to, Shane, where the metaphysics comes in. You know, the question is, where does that data reside? Where does that data reside? If we think about it as a Irish-based data, like the point of storage is the point of residence, then undoubtedly Irish law applies, and our search warrant is not worth very much in Ireland. You have to get an Irish authorization in order to access that data lawfully. But if you think that that data resides at the point of access, the United States, then you can get a warrant, search warrant served on Microsoft, and you should be able to tap into that access point in order to extract that data. And because data is just ones and zeros, we have to think, how is this battle of territoriality gets resolved? Right? However the court decides this case, I have my fairly clear views on this. However the court decides the case, I think it's undoubtedly the time for Congress to act, because it's not just about whether we need a warrant in order to access content, and it's not just about in what territory does the data reside. Once you answer the question, in what territory the data resides, that only poses the next question. Great, how do we resolve the conflicts among territories? Because all of data is interjurisdictional and potentially global, right? And so just to say that it resides in Ireland and Microsoft wins doesn't answer the basic question. Okay, great. Under what circumstances, with what procedures, may U.S. law enforcement have lawful access to that data? right? Or just to say that the point of the point of access is the point of residence of that data, again, doesn't solve the problem. Doesn't solve the problem, because what happens if a foreign country requires all persons doing business in that foreign country to have a point of access in that foreign country, right? Do we then block access to US data from that point of access? Maybe, maybe not, right? If we don't block it, does that mean that that foreign government now has a lawful point of access to all of US-based data, which is basically the reciprocation of the Irish situation, right? All of these are fairly complex questions that the court case, well, however it comes out, will only pose the questions and not provide the answer. That's why the Supreme Court, just to end on the legal note, that's why the Supreme Court, in this last case dealing with technology, Riley v. California, where the court, the Chief Justice in particular, recognized that the cloud is an entire world of our own, our entire identity. The case involved a fairly mundane doctrine of search incident to arrest. When the police arrest you, the police can get anything on your body, literally anything they want, because for safety and exfoliation reasons, they want to preserve all the evidence on your body. Pretty easy if it's a phone bill. Yep, you have access to that phone bill. What about a cell phone? Here the police, again, very ingeniously, says, I have your cell phone, I'm confiscating your cell phone, but because I have access to all of your information, all your effects, I'm gonna open up the cell phone, see who you've called, and again, they found out the address, home, and the number they call the most, and what did they find? The stash house. And then they raided the stash house, and the motion to quash was you can't. That was the fruits of the forbidden fruit. The results of forbidden fruit. You don't get access to the stash house because your access to my cell phone was illegal. The court held, again, contrary to the traditional doctrine, that search required a warrant, because that window into your life, that cell phone point of access, that window to all the information in the cloud, is such an incredible invasion into your privacy that it requires a warrant, right? And the court not only made explicit the recognition of the incredible power and privacy interests associated with the cloud, but expressly called for Congress to come into this, because however the court decides these cases in the concrete, Congress has to put an overall architecture in order to not only to define the core interest, how that core interest is balanced with law enforcement access needs, and then finally what happens not only when privacy interests and law enforcement needs conflict, but law enforcement needs conflicts with other countries' sovereignty. How to resolve all of these issues. My partner, Jeff Harris, is sitting in the back. We have copies of our white paper evaluating the various proposals currently floating around Congress. Two most prominent ones is the ECPA Reform Act by Senator Lee and Leahy, as well as the LEADS Act by Senator Hatch and other co-sponsors, both of which try to do that which I think is universally acknowledged to be necessary, which is to require warrant for content, eliminate the 180-day rule as nonsensical. The Hatch bill, I think, has the advantage of going a little bit further and prescribing the rules for deconflicting extraterritorial conflicts or territorial conflicts of these types of lawful requests, both from the United States and from foreign country. Finally, how should the Microsoft case gets resolved? Fortunately, we have a tremendous body of law on this subject. Tom and I were talking about, who specializes on this subject. We have a tremendous body of law going back to the 1700s, since the founding of the Republic, that basically says there is a strong presumption against extraterritorial application of U.S. law. It has been reiterated just a couple of years ago in Australian National Bank. It's the same issue that was presented in Keelbell, the anti-torture statute, that says that unless Congress expressly and clearly says otherwise, Congress's law is meant to apply only in the territory of the United States. Now, the government, in a very excellent argument and briefing, actually says that's a red herring, because we're not doing anything extraterritorially, right? We're serving a subpoena on Microsoft here in the United States, right? It's only if you believe in Microsoft's metaphysics would you believe that this is the extraterritorial. Of course, Microsoft says, well, only if you believe the government's metaphysics would you think that data resides at access point instead of the actual residence, which is why I say to Shane that this is a matter of metaphysics, that however the court decides, the legislature will have to make practical sense out of it. Thank you very much.
Thank you, Viet. So all of you who have children that are want to go to law school, they have to get really good at science and math first. So I'm going to forego biographies because I know that you guys have that in your packet. And we had a really good discussion about 3 minutes versus 5 minutes, and I'm giving you 3, and I have a timer. And thank you for posing more questions and answers because I think we're going to have a really good discussion here. So Greg, I'm going to start with you.
Thanks. Can you hear me?
Yep.
Hi, my name is Greg Nojheim. I'm with the Center for Democracy and Technology. Full disclosure, when Viet was at DOJ and the Patriot Act was being written, I was at ACLU. So by law, we have to disagree.
That was fun.
But today, we're going to break that law. We both agree that Microsoft should prevail in this case and that U.S. warrants should not reach data stored outside the United States. Maybe we get at it for different reasons, though. I kind of look at it from the user's perspective, right? What does the user expect? When you're out there using Microsoft, or you're using Google, or you're using Apple, what's your expectation? Is it that that you'll be protected by the U.S. warrant clause? Why? Because you're here? Because you're an American? Because your data is stored here? I think in a lot of ways, people don't really know where their data is being stored. They don't really want to have to think about these things. And they don't want a rule, though, where, and this would flow from a government victory in the case, they don't want a rule where a foreign government could reach their data as they're using a service here because they don't know what the rules are. And that's what kind of drove us toward the Microsoft position. If U.S. warrants work to compel providers to disclose content that is stored outside the United States, well, you can bet foreign governments are going to come knocking on our door and say that their warrants work to compel disclosure of your information or their nationals' information here. Well, what does that mean? The fact is that the U.S. rules, as much as we in the civil liberties community criticize them, are pretty darn good compared to a lot of the rest of the world. The UK, for example, they require that there be warrants to access communications, but the warrants are issued by their equivalent of the Attorney General. Now, that doesn't qualify as a warrant under our view. I mean, it ought to be issued by an independent judge. So the concern about what other countries would do if the U.S. won is what kind of drove us toward the view that the U.S. ought not to win, Microsoft ought to win, because we don't want this extraterritorial application.
Well done. Under 3. Extra.
And I had something to add.
And I come at this from the perspective not as much from the Fourth Amendment or the regular subscribers' interests, but from the First Amendment point of view, and the perspective of my clients who are news organizations who regularly find their emails a subject of government scrutiny and on occasion search warrants. And we don't have a reason to believe that this case involved a reporter, but it could. And we wanted to alert the court to the concerns that a reporter's email would underscore. And these are just competing values that are in place for anyone's email, but maybe even more strongly or with extra concern if they're reporters, because reporters now, just as Yet was saying, they operate around the world off of their mobile devices, off of their laptops. They email their stories in. They are in a virtual newsroom in the cloud. They're not in a bricks and mortar newsroom, notwithstanding the Washington Post is just a few blocks away. Mostly they are in a virtual newsroom. And so this is a very good example of what could happen if the government's warrant was sustained. So we put in an amicus brief on behalf of 29 media organizations, everyone from Fox News and CNN to The Guardian and The Washington Post and the European Publishers Council and other European entities. And we made 3 key points. The first was that a reporter's email, like anyone's email, are not the business records of Microsoft. So the fact that they can serve the subpoena on Microsoft doesn't mean that they have access to the emails of the subscriber or the reporter. And the Second Circuit had already held that in a case where the government had tried to get the phone records of New York Times reporters in a leak investigation, that those phone records don't belong to the phone company, they belong to the Times. The Times has whatever reporter's privilege protections apply to the Times reporters' notes also apply to their phone records. And the same goes here. Just because it's in Microsoft's cloud doesn't mean that they are not emails belonging to the reporter. And as I said, the cloud is a virtual newsroom. And in the US, we actually prevent searches of newsrooms. There's a Privacy Protection Act. And that is, again, a prevention of going through file cabinets looking for reporters' notes, but going through the cloud looking for emails is not all that different. And the third point that we made is the one that Gregory just made, which is that if our reporters are in Russia or in China and they decide they want their emails in Redmond, they'll be able to say, well, what's good for the goose is good for the gander. If you can come to Ireland and get it, then why can't we come and get it in Redmond? And I do believe that this is a delicate balance with the concerns of foreign laws. This puts Microsoft with the Hobson's choice of complying with the search warrant or complying with European data protection laws, which are quite strict. And that kind of decision should be made by Congress. And I would say Congress got it right, believe it or not. They did get it right when they unanimously passed the Speech Act in 2010. And that also involved in balancing foreign law because it instructed U.S. courts not to enforce foreign libel judgments that were fundamentally at odds with the protections of the First Amendment. I'm happy to say I got the first U.S. courts to refuse to enforce those laws. And the 2010 law came on the heels of when various alleged financiers of terrorism were suing reporters in London to try and stop scrutiny of what they were doing and getting judgments often by default in London, which does not have, English law does not have the protections that we have, and coming here to use our courts to enforce what would be a ruling that would be so at odds with our basic protections under the First Amendment. And that, kind of balancing, even though it's refusing to enforce a foreign law, is the kind of judgment that Congress has to make, I think, in this case as well. And I did go to the oral argument, and I have a feeling that this will end up in Congress's lap. I'm not sure the court's going to go as far as Microsoft would like.
Thank you, Laura. Jennifer?
Is this on?
If it's green, there should be.
Okay, thank you, and thanks to AI for hosting this. So I want to shake things up a little bit because I want to explain why I think neither side is satisfying. That Microsoft's position is highly unsatisfying, as is the government's. In the Second Circuit argument, Judge Lynch ended the argument by saying, Congress, please engage her. So I echo both Judge Lynch's claim and the claims of my co-panelists. But I also want to add that this is not just a matter for Congress, it's also a matter for the executive branch because, as Viet talked about, this data is global, and the rules that the United States decides upon are also rules that affect our international partners, and this is an area where we ought to start to begin to seek consensus across borders. All right, so why neither side is satisfying? If Microsoft wins, that means that data location controls the location of the zeros and ones, and I think that's troubling for two reasons. First, it provides an incentive for data localization laws, with governments requiring that companies store data locally so that they can retain access to that data, and that has costs to the efficiency of the internet and to cloud computing generally. And second, it just doesn't make sense that data location should be determinative of the rules that apply. I mean, data, as we've just heard, is highly mobile. Unlike the situation when one buys land or stores property in a particular location, the data user or the person with the possessory interest in the data often doesn't make the choice about where his or her data is located. And so there's normative questions about making data location determinative of the rules that apply. And in some cases, relevant data is not even housed in a single jurisdiction. Data can be partitioned, it can be sharded, it can be spread over different jurisdictions. And so there's good reason, I think, that law enforcement chafes when it's trying to, let's say, investigate a local crime about its own citizens, and it finds out that the data is stored somewhere else, and it can't get that data without going through what's often a cumbersome treaty process to get that data. Now, on the other side, I think the government's position has huge problems as well. It's the beginning of the end of sovereign control over data. The United States is not the only country who's asserting this authority. The UK has passed legislation basically saying that it can compel the production of data from any company that does business in its jurisdiction, even if it's not housed there. Brazil's considered legislation, and other nations are following suit. Under U.S. law, U.S. companies are currently prohibited from turning over content data in those situations, but that obviously creates a conflict of laws. It puts companies in a really difficult position, and I think it's going to be increasingly hard for U.S. companies to hold the line, especially if the U.S. is asserting the authority to reach outside of its boundaries to gather data. And it also creates, as I think Viet mentioned, a different form of data localization with the governments requiring that their citizens, their users, their residents use companies that are locally based or that are local providers so that they can retain control, and that's also concerning. And so whichever side wins, as I think you've heard already, we need to have both a national and an international conversation about the rules that apply. And so I just want to make 4 really quick points about that. First, as I already said, this should not be a unilateral process. There should not be the United States going at it alone. I also resist the idea that we need some sort of new international total consensus across the globe, because I think it's both highly unrealistic and I think it will lead to a watering down of standards in a way that will be quite concerning. So my suggestion is that the executive branch really start to work in a bilateral and possibly small multilateral basis with key allies, key partners in trying to come up with the rules. In thinking about the rules, I think one of the key problems is that there's currently a different standard, at least in U.S. law and other countries' laws as well, in terms of territoriality for purposes of protection of data, where the United States acknowledges that its rules for protection of data are territorially limited, and its rules for compulsion, where the United States government at least is saying that it can reach across its borders to get data, and that there needs to be uniformity in the rules governing both protection and compulsion if you want to start avoiding some of these conflict of law problems. Second, I think there's a real disconnect between the standards for content of communications and the standards for all other non-content information, which can include a whole host of information like the to/from lines, credit card information, IP address, name, user, and that type of information can tell an enormous amount of information about individuals. So there's a need in thinking about the rules to think about minimizing this divide between how we treat content communications and how we treat non-content communications. And then finally, once we reach, I mean, if we reach and when we reach an agreement about where jurisdiction begins and where it ends, when you start thinking about reaching across the borders to get access to communications that fall outside the borders, there's very significant questions about how that process works and whether governments can go directly to the companies to get access to the data or whether they have to work government to government. And the rules in the United States are that when other foreign governments are trying to seek data that's stored here, they have to go to the United States government to get content communications, but they can go directly to the providers to get non-content information. And I think we ought to rethink some of those divides as well.
Thank you, Jennifer. Greg, I realize I owe you time, but she was so interesting I couldn't cut her off.
Sorry.
Brian?
Thanks. Well, I realize that this is probably getting pretty boring for everyone since we're all agreeing on
Not
almost
true.
everything, which I'm sure was not the plan. But I do agree with much of what's been said, and most importantly, I think the urgency of the need for Congress, and not just Congress, but also, as Jennifer suggests, the executive branch, to get in this game and to start to resolve these problems. The administration could solve a lot of these problems today by changing the U.S. Attorney's Manual, by their directions to their lawyers, and by the policy positions they take. Part of the reason I think they won't is because we don't want to unilaterally disarm. Our law enforcement and intelligence agencies are not going to tie their own hands when the very countries in Europe that are pushing for us to provide more rights for their citizens, as they should, are at the same time in using and asking for much more sweeping powers in many cases than what the U.S. government has. I don't have a lot to add on the case itself. I think it's been very well laid out and developed. I would want to pull the lens back a little bit, though, and put this in a bigger context, having served not only right now as a data protection and privacy lawyer, but as an intelligence officer and a National Security Council lawyer, and maybe most relevantly, a international drug prosecutor in the Clinton administration. And by the way, because of that, I would like to be known from now on as Stash House, if you guys can just help me with that. I was an early adopter of The Wire, so I'd like that to be my moniker. When I worked on these cases back in the day, the feeling that all of the prosecutors had, I don't know if there were statistics on this, was that if you had to get into a position of formally requesting data from another government for a criminal prosecution, depended on the country, but you were basically looking at 6 to 18 months of processing time before you would get the results back. Now, in some sort of emergency situation, which I'll return to in a moment, there are other ways to get the data. But what's shocking to me is, at least according to testimony that's been given in Congress recently, it's still 6 to 18 months in a lot of cases, or longer. And this is after 20 years of development of technology. The idea that you metaphorically have to put a wax seal on a piece of paper and snail mail it to the French authorities, and then it has to go through their Ministry of Justice, then it has to go through their law enforcement agencies, and it comes back to the government before the law enforcement officers get it, and that works both ways with the other countries too, is really unconscionable at this point. And I think one of the biggest risks to privacy that we have here that we really haven't discussed yet is, if there's an emergency or a sufficiently serious crime, you can be sure our law enforcement and intelligence agencies and the foreign intelligence and law enforcement agencies are going to find a way to get the data. The French Minister of Justice, after the Charlie Hebdo attacks, did a little walking tour or driving tour of Silicon Valley and blasted American companies because we had the audacity to insist that the French go through the legal MLAT process to get the data. I mean, he all but called them traitors to the Western civilization. So it's in everybody's interest to solve this, because what we don't want to do is put our governments on both sides of the Atlantic in the position of having to resort to foreign intelligence authorities and techniques to get information that they need for law enforcement purposes. Because we've seen what happens when the government feels constrained in getting information it needs. It finds ways to break into the connections between American service providers overseas. It finds ways to get the data, and I don't think we want to incentivize that. So we want to be solving this problem, and I just want to underscore, probably no one in this room needs to hear it, but the magnitude of the problem. Viet has described his business as managing existential risk, which is an awesome job description, by the way. I might want to adopt that. But I do think my clients, at least in the private sector, and I think even from the governmental standpoint, this larger problem of how commercial companies handle data and how government intelligence and law enforcement agencies get data is approaching something like an existential problem, at least for the companies. They're in a position now where they've lost a lot of consumer confidence, even if they're perceived as cooperating with the U.S. government, even when they didn't necessarily cooperate. And on the other hand, they're subjected to these conflicting laws with our country and other countries basically saying, yeah, you have to comply with both and pick which sanction you want to take if you don't do so. So I think we really need to have a wake-up call here, and if we needed any more evidence of that, I can't believe it took us 40 minutes to get here, but the European Court of Justice in the last 12 hours just invalidated the safe harbor agreement that the United States has with Europe, which thousands of American companies use to lawfully transfer data back from the EU about EU citizens to the United States. So that is a little hard to tell in any European Court of Justice opinion, but I think the summary of it is chaos. And this is all of a piece because the reason why the European governments came to this position and the reason why this litigation got so far, I believe, is because of the Snowden revelations and European citizens' concerns over U.S. government activity. So I don't think this issue could be more timely.
So, Greg, I'm going to give you a little time back, but with a specific question, which is, do you think Congress can save us from this metaphysical quagmire?
I think it's a challenge for Congress to act on most anything. So, no, really, I mean, let's just say it up front. I've been working on reform of the Electronic Communications Privacy Act since before the Patriot Act. I mean, really, we had a bill to reform ECPA before the Patriot Act. 9/11 happened, put everything off, and now there's so much adversity, it's really hard to get things done. The ECPA reform legislation now has 300 co-sponsors. 300? I mean, that's more than 2/3 of the House, and yet we still haven't gotten a vote. So I think counting on Congress to rescue us, it's risky. There may not be great alternatives, though. I mean, we just don't have great alternatives. Can I respond to Stash House
Absolutely.
here?
Stash House.
Okay, one down, thanks.
So it's not to disagree or anything, but it's that we talk a lot about the interests of governments. They're important. We talk about the interests of law enforcement within governments. They're important. What about the interests of that person who's the data subject in this case? He's probably an Irishman. Maybe he lives in the UK. What does he want? What does he want? Does he want for the rule to be that the U.S. has the say over whether probable cause must be shown to get his information? Does he want that? Or does he want the U.S. to go through the MLAT procedure, in which case Irish law would apply, and there isn't a probable cause requirement, but there's a different Irish requirement? Does he want that? Does he want it because it's Irish? Or does he want probable cause because, frankly, the standard is pretty high? And I think that we haven't really heard from the rest of the world, what do they want?
Yeah, I agree with that 100%. And I think one of the other major privacy risks here, which Greg has alluded to, and I think it's a reputational risk as well for the United States, is almost all the solutions that have been talked about involve some degree of, I would say, dumbing down U.S. constitutional protections for data, content of electronic data taken out of the United States by foreign law enforcement agencies. And I just don't think that's politically viable. I don't think it's acceptable, actually, under American values. It sounds a little imperialistic, but I don't think it makes sense for the United States to create a regime where the content of Americans' communication can be taken out of our country by a foreign law enforcement agency under lower standards than our own law enforcement would be able to get it. Now, many of the proposals carve out U.S. persons, and I believe the LEADS Act does this, carves out U.S. persons from that requirement or from that lowering of the standard, and that's helpful and beneficial. But I agree with Jennifer, too. We're not going to get an international treaty signed by 180 countries or whatever, at least not in the foreseeable future. What we should be doing is working with our closest allies that have the closest types of judicial protections to what we have, even if they're not the same, and incrementally getting these bilateral agreements and setting the standard so that at some point when the countries further out from that core want to get data from the United States, they basically have to sign up to it. Because, I don't know, I feel like we sort of relearn this every 10 or 15 years in the United States. We can't talk other countries into doing what we want. We have to get agreements that they think are in their national interest. And we're just not going to do that with 180 countries or whatever at the same time.
Viet, you have a response to that?
Not a response, but just a note that I think everybody that shares, but I want to make express. The office none of this is a commentary on the Department of Justice. Obviously, the people at the Office of International Affairs, some of them are here, Harry Marshall and Michael Yoon and others are here, are some of the best lawyers that we have in the Department of Justice, doing tremendous amount of work under tremendous amount of constraints. I think every single internal and external reviewer has said that the expectation is too high, the research is too low, and the user friendliness of the system is dismal. Most of the time is spent, the 16 to 20 months is spent sending back applications because they do not meet the letter and the wax seal requirements of the MLAT regime. So I think that giving the resources for the process to work properly, having the right technology, there's no reason why we should not have an electronic clearinghouse in order for the submission, processing, and delivery of these materials, and respecting that regime rather than trying to find what I call the equivalent of data rendition by sidestepping this multilateral regime is the answer.
Yeah, I just want to add one other point, which I think has been implicit in what we've all said. I actually think there's a great deal of good news here for privacy, and that is that I think everyone, or almost everyone, certainly everybody at this table agrees that we need to change American law so that the content of electronic communications is protected by the warrant requirement, whether it's 179 days old or 181 days old, and however it is stored and transmitted. And I know CDT has been advocating for that for a really long time, so I don't want the victory or expected victory to be lost by us saying how complicated all the rest of this is.
And I would agree with Jennifer's comment that the bright line that's been drawn between what we would call metadata, basically phone numbers and things like that, and content should be looked at again too, because obviously so much, certainly for reporters, who they contacted is as important as what was said, and that I think it deserves the same kind of strenuous protection that the content communications have.
So the strange thing about the metadata rules, I find it strange, is that the rules for a foreign government's access to your metadata are actually lower. The bar is lower for foreign government access than for U.S. government access. Now, I think some might say, well, we should lower the bar for U.S. government access. That's not where I'm coming from. We need to raise the bar for foreign government access. Because the rule right now is that a provider may disclose a record, for example, of who emailed you and who you emailed to any foreign government that asks for it. That's U.S. law. That seems absurd. If the U.S. government comes to the provider and says, give me a record of who you emailed and who emailed you, the provider will say, go to court, get a court order, and the court order, it doesn't require probable cause, but it requires specific and articulable facts that information is relevant and material to a criminal investigation. It's kind of an intermediate level of proof, and there's a judge making the decision. That anomaly seems absurd and should get fixed. I want to add, though, from the provider's perspective, that anomaly is a very useful thing, and we can't ignore it. From the provider's perspective, they get the demand from the foreign government. It's often for the content and for the metadata. At least they have the ability now to give the foreign government, if the provider thinks the foreign government, has at least some level of respect for human rights, they can give the foreign government the metadata, even though they can't give the content. So it takes some of the pressure off the provider to be able to give the metadata and send the content requests through the burdensome MLAT process.
Yeah, I'd just add. I mean, I agree with everything that Greg just said, but I also think it's interesting to think about what kind of, in some ways, burden that places on the companies to effectively be in the role of doing this type of human rights vetting that Greg was talking about, without any clear rules, without any clear standards, and different companies, from my understanding, do it differently. Big companies, the major companies, have whole units that are dedicated to doing precisely this type of vetting, and they're capable of doing it. But they're not the only types of companies that are going to be getting these types of requests for non-content data. And think about a teeny company that's a startup, and that they're not going to be in a position to be able to vet these requests. And it raises, I think, really important questions about how much power is being delegated to these companies in terms of making these decisions. I just wanted to respond to one other thing that Greg said earlier, which is about thinking about the perspective of the user, and what does the data user, the person with the proprietary interest in the data, what does that person want? And I think that, again, points to the importance of having some stability, some clarity about the jurisdictional rules, because once there's clarity, whether it's data location, which I think there's problems with, or whether it's the citizenship of the user, or whether it's user location, or whether it's where the headquarters of a company is located, whatever we ultimately decide, both independently as a U.S. government and also ideally with our partners, are the rules for the jurisdictional rules. Then users will be able to make some choices based on a stable set of expectations. We don't have a stable set of expectations right now.
And I agree with that, but then the problem becomes not only the user who's a good guy, but the user who's a bad guy. He's going to know what the rules are, and he's going to choose the rules that are most advantageous to him hiding the crime. We've got to account for both of these.
Yep, I agree with that. I mean, and lest you think that there is no disagreement on this table, I have not become a card-carrying member of the ACLU.
What?
Yeah, I'm sorry. I know, Greg. I know, but I'm just a.
You can support CDT, though.
There you go. The fellow travelers, I'm glad glad to have on the road. I come at this from a law enforcement perspective. I actually think that it is better and more efficient for law enforcement to do their jobs if the rules of the roads are more clear and multilateral rather than unilateral. Recall 9/11. The experience of that investigation is that we cannot go at it alone. We need the Germans, we need the French, we need the Malaysians, we need the Saudis, we need everybody in order to help us in that. And the more we go at it alone unilaterally in specific instances, the less there is going to be a multilateral framework for efficient, consistent, and persistent cooperation. That's why I think that these types of Band-Aid and paperclip solutions that are done at local U.S. attorneys' offices really has a very strong structural adverse effect on the ability of DOJ to do its work on a day in, day out on a permanent basis, because when a Charlie Hebdo happens, we don't have the infrastructure in order to have instant multilateral response. When a Charlie Hebdo happens in the United States, we have the converse. Everybody still feels sympathy, but everybody also has legal handcuffs around them that are put in place precisely because of tit for tat, the offense and defense that comes with unilateral decision making. And that's why I think that ultimately it is in the interest of law enforcement to have consistent rules that are universally acknowledged, and thereby making the work more efficient. If you have to accommodate the civil libertarian concerns in order to get those law enforcement tools in place, by all means do it, because that's a side benefit. But even from a unilateral law enforcement perspective, you should have these rules.
Well, I hate to disagree about the degree of disagreement, but even there, Viet, I think you're in agreement with Greg, because from the privacy, at least from my view of the privacy and civil liberties perspective, another benefit of this regularized, well-known and understood process of exchanging information is when there's an emergency like Charlie Hebdo, you don't automatically drive the cooperation into the black or dark gray world of intelligence sharing, which I'm just telling you, when there's an attack like that, particularly if there's evidence that there might be a follow-on attack in the United States, that data is getting shared. It's just a question of whether it gets shared in a privacy protective way or not.
Does anybody else want to comment on that? It's kind of a break the glass element that you think about when you're doing healthcare. I mean, like, if it's a survival situation, do I think about the ramifications afterwards? No, I'm gonna let that one go. We have so much on the plate right now. I don't even know where to head next. I was actually thinking about the data localization and what corporations do to try to hedge in this situation. Is there a path forward where they pick some countries over others to stick around in and try to keep people from using their services because of where they don't want to be in a jurisdiction?
I'm not sure this is an actual plan, but do you recall a movie called Pirate Radio?
Yes.
I'm
waiting for you to get to Breaking Bad at some point.
It's about the hyper delocalization, right? Where some guy gets a ship out in the English Channel and it's away from the jurisdiction of any terrestrial thing and beams his beams in. It's not a far-fetched plan if you're subject to so far. We're talking about authorizing legislation, the UK legislation. It's not hard to imagine a world like in financial services right now where there's going to start being blocking legislation. It is illegal for you to turn over data to foreign governments, and then you'll be as a service provider, you'll be caught between a rock and a hard place. When it starts being global, blocking and authorizing legislation, the only place you can escape is essentially outside the world of territorial jurisdiction, and you will see solutions like that. It doesn't really need data doesn't really need the terrestrial location. You can think of islands, you can think of barges, you can think of all various mechanisms in order to locate servers that are increasingly.
There's already examples of this. I mean, in Brazil, there were 2 American service provider executives in separate incidences literally taken from their homes by law enforcement and put under arrest, or at least threatened with that, because they were accused of either not giving data to the Brazilians that would violate U.S. law or giving information to the U.S. government that in the opinion of Brazil, would have violated Brazilian law. And there's also a great, long but great novel on this topic called Cryptonomicon from, I think it might even be a pre-9/11 novel about a bunch of libertarian entrepreneurs who literally buy an island in the Pacific with the specific intent of creating a data haven that's not under the jurisdiction of any country in the world. Problems ensue, but that was the plan.
and one judge on the Second Circuit predicted, not in this case, but in the New York Times case I mentioned, that reporters would resort to the tactics of drug dealers with throwaway cell phones and that people go on Tor and other encrypted sites, anonymous sites, and that will develop more and more. And of course, there is the big fight over encryption and the tech companies wanting to encrypt more and the government wanting.
Okay, whatever your reporter clients do, just remember I'm Stash House. You got to come up with some different name.
Well, what about Facebook wanting to use satellites? Do they use certain companies that are going to adhere to it? If you go with your kind of, pirate, get outside the, are we extraterrestrial? They're talking about, how do we utilize this from here on out? I mean, it's getting interesting.
I think what we need to have is a system that allows for the disclosure of information when a government request meets a relatively high standard and the information is not going to be used for a violation of a person's human rights. I think that's the goal, that's the progress, that's the direction we need to move in. How do you get there, right? Congress has to be involved, right? Because it's going to be a law. Other countries are going to have to be involved because we're going to want them to adopt the same rule. But is there something that we could do in the United States to kind of set an example, to take the lead, to move in that direction? My organization, CDT, we've put forth what we call a straw man MLAT reform proposal. And the idea is that in very short time, the U.S. would adopt a rule that says we're going to allow for foreign government requests from countries that have good human rights records, good surveillance laws. We're going to allow for those requests to be made of the companies directly, but we're going to put the DOJ in a circuit, the Department of Justice, in a circuit breaker mode so they can cut off disclosures to foreign governments in particular cases where they'd be used to violate rights. We put it up on a website. It's www.cdt.org, and we'd be happy to receive commentary on it because I think we're going to start moving towards some kind of reform regime.
If I could just I encourage everybody to look at CDT's proposal, and it's interestingly one of a number of proposals that are kind of floating out there about what's often described as MLAT reform. And I just want to kind of beat what's probably a dead horse at this point, which is that MLAT reform is helpful, and all these proposals are helpful, but you still need to address the underlying jurisdictional question, because all of this kicks in at the point that one nation's jurisdiction ends and another begins. And so any of this requires, I think, first an answer to this question as to what is the trigger for jurisdiction. Is it the location of data, as Microsoft says? I think that's a bad idea. Is it anytime the company is located in the jurisdiction so that it's the access point, which is what the U.S. government says? I think there's problems with that as well. So I think we still need to address this underlying jurisdictional point. The LEADS Act that somebody mentioned has another answer, which focuses on the citizenship and also the citizenship and legal permanent residency of the person who's being targeted.
So Jennifer, you've eliminated two possible answers. You've mentioned a third. What's your answer for the jurisdictional question?
Look, our time's up.
I think it's really hard, and I don't know. The answer is I don't know. I think that all of the answers have both pros and cons. I think that some combination of possibly citizenship, location, and maybe things outside of things like the nature of the crime also which ought to play into it. But I don't have a definitive answer right now because it's really hard.
I'm going to open up to the microphones in a couple minutes. I was going to see if there's any last comments you all wanted to get in while you still have control of your time. No? Stash House is looking pretty happy over down there. Okay, that's
all good.
Well, I guess one question is, do any of you think that technology is going to be the one to solve this, or are we, because it seems like we've got a bunch of really smart lawyers up here and everybody's scratching their heads.
Well, this is part of what I was alluding to earlier when I said the executive branch could do a lot in this area with no change in the law. It's honestly ridiculous that there's not already an electronic system of contact from governments to governments where there's a 5-field form you can fill out, and that would have I think not only an efficiency benefit but a civil liberties benefit too, because then you're going to generate data that can be audited and can be analyzed to figure out how long are the delays really? What kind of crimes are the delays? I mean, is it much faster in a terrorism case than a child abduction case? And you can start to make some rational decisions around that. Right now, as far as I know, there's really no good data on that at all. So I think technology can do a lot to help solve the problem. But again, it's not going to answer the fundamental question of where do you start your analysis in terms of which country's jurisdiction should cover a piece of data. Although even there, I think it will help, right? Because a lot of the problem, and this was part of the problem of why we needed FISA, Foreign Intelligence Surveillance Act reform, is it's so hard now in real time or near real time to determine the citizenship of a person and the location of data. And technology by itself isn't going to solve that, but it could go a long way to mitigating that problem.
In answer to your question, a deeper level in terms of the technology companies and infrastructure response to this problem, let me be clear. The world I envision in which everybody goes offshore is a dystopian world. It is a world that does not work. We've heard in the first iteration of the internet how the internet is this new cyberspace, therefore unregulable by any jurisdiction. Wait until the Silk Road executive goes to jail, right? As just happened this last year. It's just the thought that somehow technology can create a world whereby normal rules of social contract do not matter and should not matter is an illusion, because governments are there in order to enforce their laws, and we should try to think through ways in order to deconflict those laws rather than trying to eliminate them. And so, short answer: no, I do not think technology will solve the underlying jurisdictional and diplomatic problems. But technology, like money, is very, very fungible and very, very fast moving. And so there will be workarounds, and there will be band-aids and paper clips, whatever rules you put up, and there will always be people who try to evade the law by use of technology or by the choice of law the rules. But that's nothing new. We've dealt with that since the beginning of law.
Okay, gonna go out here to the audience. We got right here in front? We've got somebody in the. Can you identify yourself and tell us who you're affiliated with?
Hi. Sharon Bovat, Voice of a Moderate. I have a question about, you were talking about the burden of big companies. I'm a little company. I do new media journalism, and actually my website about corruption was read by the bloggers in Egypt that were then arrested. And then I was told not to travel to Egypt because, they have the IP addresses. They know that they were reading my things before they did, even though I had nothing to do with that revolution. I then learned that a French company was mad, and I was one of the reasons because my web page was floating to the top in Google, that the French really wanted their right to privacy. And so I've been told that when traveling now to the UK, I should start flying into Ireland instead of England because of a certain situation that happened with my luggage being overly searched. I almost missed a flight. So I'm learning that data and data protection affects everybody. And we don't know what the rules are and if there were a code of conduct, because the Iranian server is in Ohio, and that was publicly said at AEI. And I had a hack from Iran, so I'm like, why can't you go after them because there are servers in Ohio, and they can't. So there's a lot of complications with this internet society. So maybe a global organization, I'm not saying the UN, but maybe the UN needs to do a global code of conduct and just so everyone has a baseline of ethics. So I didn't know what you would say about that, but I do understand it's a burden to companies, but also individuals.
Thoughts about engaging the UN on this?
I wouldn't do it. No, I mean, they're a fairly effective convening authority to bring people together and debate ideas, but the problem is, same reason you're never going to have a universal cybercrime treaty. The United States and our allies don't believe the same things as the Chinese and the Iranians and the North Koreans and the Russians, even to a large extent. And this idea that if we all just sit down and talk to each other, we're going to be able to agree on everything is fantasy. The Chinese are never going to agree to the same rules of the road that the United States wants to agree to, unless they're just at such a baseline lowest common denominator level that they don't really mean much of anything. So color me skeptical.
And I would say that even what the community that we consider allies has different laws. The data privacy protection laws in Europe are now causing the right to be forgotten, which is a rule from the European highest court that says that, well, just because you were arrested and convicted 12 years ago, that shouldn't be on a Google search anymore because that's history. And that gives the power to Google to decide, well, is that important? Is that newsworthy? Should we keep it up? Should we not keep it up? That they have a whole huge department that's trying to decide that. And it affects, at the moment, it's not allowed to reach news sites so that the archives of the original news story is still there. But most people find things now by putting a name in Google, and you won't find it. And Bing and all the other search engines now are having to go through, in Europe, this elaborate process.
Yeah, just to reinforce that point about lack of agreement, even among Western democracies, there's 10 examples of this, but the French lower house of parliament this spring, I haven't tracked where this law is now, but they just passed a sweeping spying bill that really makes the Patriot Act look quaint by comparison.
It is quaint. It's very measured.
Yes. Well, so it's being exposed for the measured piece of legislation it was. It allows the French intelligence services to deploy tools to do real-time 24/7 vehicle tracking and mobile phone identification against individuals without any judicial oversight at all. Allows the government to force communications companies, including U.S. companies, to go on their own and unilaterally sift through phone and internet data looking for potential terrorist communications and then requiring them to be reported to the government. And it gives French intelligence services real-time access to any data that could show a connection between terrorists. So I'm even more skeptical of a UN process than I was a minute ago. Thanks for bringing that up.
Have the French disconnected the Minitel yet? I think they're such optimists, really. Looking at it from the wrong end of the lens. Back here, girl, grab one of them there.
Oh, thank you. My name is Tom Gross. I'm an attorney in town and also with George Washington University. So I just want to focus on this, the way the question was posed, which is, where is the data located? And I would suggest that's an antiquated question, that's the wrong question to ask, because it's based on the view that these documents are physical documents. That's where that question originally comes from. And this is what Jennifer is saying, is why should jurisdiction be based on location? You know, you don't even have to take the server offshore to get to that point. Suppose you have a company that's storing the data, but the physical servers are in different countries. So now you have one in Scotland and England and Germany. And now when someone goes to an access point and accesses the document, it's kind of like you send an email where it goes through the internet and the addresses in the header go through all the various aspects of the internet, and then it's reassembled at the delivery point. Now you reassemble the document by going to Ireland, Scotland, Frankfurt, and you reassemble it. So in that case, there really is no physical location. The electrons are all over the place. So I think my comment here for you to comment on is maybe you're asking the wrong question. Should it be, you know, it has nothing to do with data location.
So say location doesn't matter. Put location aside for a minute. What should be the determinant? Should it be nationality, your citizenship? Should you carry around your right to probable cause and due process no matter what country you walk into? Probably not. Should it be the nationality? Well, place of incorporation? No. Place of major operations of the company you're doing business with? Should that be the determinant? I think it's really hard to come up with a good answer, as Jennifer was saying. And no answer is going to be completely satisfying. We're going to kind of wander our way through this after a lot of discussion. And really, events like this are where we start to have those discussions and about what should happen.
This event's just giving me existential angst. But yeah, go. Did you have another comment on your comment?
I think that's exactly right. Those are the questions we're trying to answer. But you know, it's something we have to work through. And I really like Brian's suggestion. You're not going to get 180 countries to agree on this if you get them at a table. But if you get the major G7 or 8 countries, you know, the United States and European Union, to use these kinds of Western standards to set a standard, then you've got something to follow. And people don't, other countries and areas don't have to follow it. Maybe they will react to it and do their own system, but at least then you've got some core values to look at and evaluate.
But this is why I'm not good as a diplomat. Even to
that's why.
Yeah, exactly. Yeah, I cannot see a path post Snowden to get the G7 together on this. And that's before we pose the question, which is, you know, extra metaphysical, which is a non-physical question, right? We're not there yet. Just as a technological matter, we're not there because there's still latency problems between the connections, and so generally data is in one place. It just happens to be the nearest place where the user is, and so it's not completely disaggregated. And I don't think that we will ever get there from a complete total disaggregation. And so there's always a physical location. So the territorial limit still is. You know, that's why everybody defaults to it, because it's a very good tiebreaker. Ever since the Treaty of Westphalia. Right, it became, and before that, it was a really long war, and so everybody understands the theory of territoriality as the defining construct in jurisdiction. And once you get away from that, it gets a lot harder. Territory plus some notion of nationality may be an answer, but it is a hard one.
But, so I agree that territoriality has to be a piece of this, but it's territoriality based on what? So right now, I mean, is it territoriality based on location? I think that has huge problems for a whole host of reasons. So is it, as the government says, territoriality based on where the company's located? Is it territoriality based on where the user's located? And so I think, I mean, my personal view is that data location is probably the worst of all of these options because because of the instability and the difficulty of identifying it in any sort of permanent or semi-permanent state. All these things are mobile, but data is the most mobile of all these different options. And so we still need territoriality, but we need to answer territoriality based on what?
How about where the crime happened? Do you want to try that one?
That's an option too.
We're all doing an amazing job of dodging the question. And the reason is because it really, I mean, I was in government 15 years. This is one of the hardest questions I've ever seen. And part of the problem is we don't have any hard data. I mean, this issue that you bring up of whether the packets are separated and stored in multiple locations at the same time for data retention and recovery, disaster recovery issues, logically and based on discussions I've had with my clients, exists, but I don't think anybody thinks they know how big a problem it is, how common that is, how frequent it is that companies store only in one country. And part of the reason, I think, why the judge in the Second Circuit case, all but in so many words, begged Congress to get involved, is there's a sense throughout our constitutional history that the Congress, the legislative branch, is the place that can have hearings and can bring people like the people at this table in, bring the service providers in, generate this data and do an analysis that I don't think has been done yet about what the consequences are of the various solutions. The one concrete thing I'll say is, to try to slightly less dodge the question, is I do think we ought to have as a principle as we move through these possible legislative and other solutions that whatever the United States decides to do unilaterally, as Greg says, to set an example, needs to also have a reciprocity requirement. So some of the legislation right now, including the LEADS Act, has some really valuable things that the U.S. government could do to increase the rights of non-U.S. citizens and to make the process better. But what I think the treaty negotiations, bilateral agreements, and the legislation should have is some notion, if you're UK or you're France or you're China, you don't get the benefit of the U.S.'s improvement in the process unless you're willing to give the same benefit to our citizens. And I think there's relatively easy ways to do that in legislation.
Let me just round off by limiting the problem a little bit. It's not as intractable because of the separation of metadata versus the actual content. Microsoft here comply with the subpoena by turning over all the metadata related to this one user and this one account, because because that metadata is truly, when you think about it, truly Microsoft's the business records, if you will, in tracking this where they locate the content. And so, if the situation is that you will never know where the information is, that's answered by a regime covering metadata. That is the pursuant to lawful the command. You have to issue the metadata to show where the location is, and if the location of the data happens to be within the jurisdiction, then of course you can they have jurisdiction. But it happens elsewhere, you go to that jurisdiction. So it's not like a wild goose chase in the sense that you're hiding the data behind three different shells, because you show the government where the data is.
So the metadata, going back to Stash House.
Right, exactly. you give the address of the stash house. How you break it down is completely your business.
So do we create a Barbary Coast of one country that decides they're gonna do the antithesis of this? They are absolutely gonna say no. It could be Venezuela. It could be just like, great, come on over. You'll enjoy the beach. We will not give you a damn thing.
So the technological equivalent of Delaware.
That's kind of, yeah. All right, we got time for one last question. I'm sorry I've kind of ignored this side of the room. Anybody over here? All right, girl, the woman here in the yellow. Yeah, your final question. Be a good one.
I hope this is a good one. My name's Elaine Middleman. I'm an attorney, and I'm going to use this as a hypothetical. What if Hillary Clinton had stored her data in Bill Clinton's cousin in Ireland's basement instead of her basement? Would Ireland then have a claim to the State Department data?
With lawful access, yes. According to the dictates of Irish law, whatever the regime of Irish law would be, I would suspect that it requires some showing of, if not probable cause. Actually, no, the Irish does have probable cause.
Except in this case, the government, the subpoena is directed at Hillary, and so Hillary, as the data owner, as the data user. If there were a subpoena directed at her, she can produce her own record. So there's this, one of the ways that this becomes more complicated is because we're talking about a third party controlling the data. Yeah. So if the question is, what happens if the government tried to, instead of going directly to Hillary Clinton, to go to whoever was managing her server, then I think Irish law, according to the Microsoft position in the Microsoft case, would control.
It would be solved if we can all have our own personal servers.
Except for we found out that her server was really not her server, it was in Colorado. So continues the whole question, where does it actually go? Thank you all for a great panel discussion. Please thank the panelists with me. And just once again, if anybody wants a copy of Laura's amicus brief, we will let you know where to find it.
Oh, and just our MLAT reform proposal is out front if you want to pick it up on the way out.
I will. Thank you very much.